Consumer debt defense. Lots of South Carolinians take out short-term loans to cover bills and use household goods as collateral for the loan. Collateral includes things like TVs, computers, jewelry, yard equipment, and game consoles that the lender can repossess if the loan is not paid back. Part 1. Laws that protect you. If you are being sued by the finance company for this kind of loan, you have a lot of rights, even if you do owe the money. For example, the company has the burden of proof. What that means is they have to prove that you owe the debt. You don't have to prove that you don't. 1. Jail. If you don't have the money to pay the loan, or you threw away old broken property that you used for collateral, you might be afraid of going to jail. Don't worry, you can't go to jail for those reasons. Debt collectors sometimes threaten people with jail if they don't pay. This is an empty threat. You cannot be sent to jail for not paying a consumer debt or for no longer having the collateral, unless you sold the property and didn't pay the finance company. But that doesn't mean you can hide the property, say you don't have it, or have someone keep it for you. 2. Protected wages and property. The finance company or even a judge might encourage you to set up a payment plan. But don't agree to a payment schedule that you cannot afford. That's what got you in this mess to begin with. Even if you think you can afford it with your paycheck, you don't have to. Your paycheck, your home, and even some cash in your bank account are most likely protected from being taken to pay this kind of debt by the exemption laws. The finance company is not allowed to garnish your wages in South Carolina either. This means automatically having some of your paycheck taken away. Even if they do win in court, they can't force you to sell a home, car, or other property to pay back the debt unless a circuit court judge orders it in writing. Part 2. Personal property collateral. 1. Claim and delivery orders. If you have put up some of your property as collateral on the loan, the finance company can't just come to your house and take it. They need to go to court, win their lawsuit, and then secure a claim and delivery order, sometimes called a pickup order. Finance companies sometimes call borrowers and say that they will send the sheriff, that they are calling the police, or that you will go to jail if you do not give them the property or pay them any money. You cannot go to jail for that. It is not a crime to not have the money to pay a consumer debt in South Carolina. The company cannot come in your home or make you give them the property without a court order. Finance companies are also prohibited from calling family members or friends to embarrass you or to get permission to enter your home. Make sure to tell your family they do not have to respond to those calls. 2. Depreciation. Sometimes the property used as collateral will wear down, break, or you may have thrown it away. You cannot go to jail because of this. The lender took a risk when they used your property as collateral. If it deteriorates, that's their problem, not yours. This is true even if you buy a new version of the item. If you put an old TV up as collateral, then bought a new TV, they only get the old one. You should keep everything that you used as collateral, even if it breaks. If you are sued for claim and delivery, the easiest way to respond is to give them all of the property that they are asking for, if you still have it. For the lawsuit, it's important that you make a list of every piece of property named by the finance company. It's okay if you don't have the property in mint condition. If you don't have the property, say what the current value of it would be if you sold it at a garage sale. For more help, you can find resources at lawhelp.org or contact South Carolina Legal Services to find out if you are eligible for an attorney to help you for free.